The Constitutional Court has now said it will hear arguments for the Council for the Advancement of the South African Constitution about why it believes Casac should be allowed to argue in the case around whether former President Jacob Zuma can be a candidate for Parliament. The Electoral Court has ruled he can be a candidate after the Electoral Commission had upheld an objection against his candidacy. The Constitution says someone cannot be a Member of Parliament if they've been sentenced to more than 12 months in prison in the last 5 years. Lawson Naidoo is Executive Secretary at Casac. Lawson, good afternoon to you, and I appreciate you taking the time on a public holiday. So you're being allowed to argue in front of judges that you should be part of this case. What kind of arguments are you going to make? Why do you want to be a part of this?
Good afternoon, Stephen. Thank you very much. Well, Casac believes that this is a case of fundamental constitutional importance and public interest. And we want to participate in this case to try and assist the court with the proper interpretation and understanding of Section 47 of the Constitution, which deals with membership of the National Assembly. And then in subsection 1 deals with those people who are not eligible to be candidates for election to the Assembly. And 3 of the categories, I think, Stephen, are particularly important to understand the purpose of that provision in the Constitution. So it precludes unrehabilitated insolvents, persons of unsound mind, and persons who have been sentenced to a period for more than 12 months in prison. Each of those 3 categories requires a determination by a court in terms of sequestration, must be by order of court. The declaration of someone being of unsound mind must follow an order of court. And similarly, a conviction and a sentence is that pronounced by a court of law. Our argument is therefore going to be that any executive action in terms of remission or parole cannot have an effect on that sentence and conviction. And it should not be in the purview of the executive to override a judicial decision when we consider the separation of powers. And I'm sure, Stephen, you can imagine if the executive and if political players were to override that in terms of eligibility for the National Assembly, how that political influence could be abused in order to benefit certain people in certain circumstances. So I think the Constitution is quite clear. This is a judicial determination, and the court, I think the Electoral Court, did not fully appreciate the distinction between the remission of a sentence and a pardon. So the remission of the sentence has no impact on the actual sentence itself. It's merely about how long a person has to serve, which falls within the responsibility of the executive, the Department of Correctional Services, and so on.
Okay, so another way to look at it is that, as in the clause of the Constitution that you've quoted, it says sentence. The kind of full stop is there. There's nothing about what happens after the sentencing in terms of remission or parole or pardon or anything like that. It just says sentence, and that's where it should stop.
Yeah, and then there's an exception that comes in after that full stop, which talks about the process of an appeal. And this is another basis on which the Electoral Court found in favor of the MK party and Mr. Zuma, saying that because the sentence was imposed by the Constitutional Court and there was it was therefore not appealable, that exception should apply to him. But clearly it does not, because if you take an example of another case which might have gone through the court system, through the High Court, and comes to the Constitutional Court on appeal, they have the capacity, as the Constitutional Court, to increase the sentence on that offender, and there's no appeal against that. So the non-appealability of the sentence is immaterial in this case.
So I was going to come to that because, and just to go back a little bit, it's one Constitutional Court. It's where it all gets very messy, Lawson. It's one Electoral Court ruling by 5 people, 3 judges, 2 professors. They wrote 3 separate reasons or rationales for their decision, but they all agreed Zuma should be able to stand. Okay. One of the things within that is that, as you say, the main rationale or the main reason for why Zuma can stand is because he was sentenced by the Constitutional Court and therefore there was no prospect of an appeal. And if I were to argue what you're arguing, the other aspect of it would be that if you'd been sentenced by a high court and there'd been no appeal, it would mean that a high court sentence had more power than a sentence from the Constitutional Court, and that can't be right.
Indeed, and I think that exposes the lack of reasoning by the Electoral Court in this matter, and they completely misunderstood the purpose of that proviso in Section 47, one of the Constitution, and we believe that they got it wrong on that ground, and that was the ground on which all five judges in the Electoral Court agreed. On the issue of remission, there were different reasons for coming to the same conclusion, and as I've demonstrated. The other thing, Stephen, is this is a provision in electoral law, electoral systems across the globe. So we're not the first country in the world to deal with this. And one of the issues we want to bring to the attention of the Constitutional Court is how other jurisdictions have dealt with this matter in the past, what the comparative law and foreign law jurisprudence tells us. And it tells us that the Electoral Court got it wrong, that there have been cases very similar to this, where the issue of remission of sentence came before the Supreme Court in India, for example, and found, in a manner consistent with the way that the Electoral Commission determined this matter, and not the way in which the Electoral Court did.
There's another aspect to this, and if I understand the Electoral Court ruling, or rulings properly, it says there is no distinction between whether you qualify to be a member of Parliament and whether you qualify to be a candidate to be a member of Parliament. Now, this is important because it gets to the heart of the question of who actually makes the decision. And as I understand the ruling, it is saying that the Electoral Commission decides that Stephen Crotus is qualified to go to Parliament or Stephen Crotus is not qualified to go to Parliament. How important is that? Do we need the Constitutional Court to rule on that aspect of this case?
Well, I think given that the Electoral Court has raised the issue, I think it is now incumbent on the Constitutional Court to make that determination. What the Constitution says in Section 47 is talks about people who are eligible to be members of the National Assembly, and the Electoral Act gives the responsibility to the Commission, the Electoral Commission, to manage elections, and managing elections must include making a determination as who's eligible to be a candidate for that election. To say, as was argued before the Electoral Court, that is a matter that can be left for later and a matter that can be dealt with by the National Assembly itself. Well, again, that confounds reasoning, because at what point does the National Assembly make that determination? Does it make that determination after the person in question or the people in question have been sworn in as members of the National Assembly? Do they participate in that process? Surely that cannot be right.
One of the issues with this entire case, Lawson, is the length of time it could take to make a decision. Now, it may be relatively easy or quick for the Constitutional Court to make a decision about whether or not the argument around the Constitutional Court sentence versus a High Court sentence stands. That distinction may be easy to make. So too the distinction we've just been talking about between being whether you qualify to be an MP or whether you qualify to be a candidate to be an MP, and the roles of the IEC. In fact, all of that could be cleared up pretty quickly. I worry slightly about the arguments around the effect of a sentence and a remission. Because the Constitutional Court is the highest court, and because its judgment either way in this case will set a precedent, this has the potential to become quite technical. I'm not concerned about the technicalities. That's the lawyer's problem, not mine. I am concerned about the length of time it could take for the judges to make a decision, because they will have to hand down a judgment. And I don't know if you remember, but we're 28 days away from an election. By the time they hear the case, which will be the 10th, they'll have just over 2 weeks to make a decision. And it will be quite an important decision for the election. And I think it would be fair for voters to have the information about whether or not Zuma is a candidate for MK or not before they vote. Are you worried about that?
Indeed, I think we should all be concerned about that, Stephen, because we want all of these issues to be resolved ahead of the 29th of May, because they impact on the freeness and fairness of the elections that are going to be held. If there's any doubt as we go into the election as to the eligibility of certain people to stand for office and other disputes that are lingering. It's unhelpful. So certainly I hope and I would assume that the Constitutional Court has issued its directions in terms of the timeframes leading up to this hearing on the 10th of May, which is next Friday, that they feel confident enough that they will be able to give us an answer, an order, if not the reasons for that order, in advance of the 29th of May. If they fail to do that, or fail to even give us a decision, and in this instance, Mr. Zuma continues to be a candidate on the strength of the Electoral Court ruling, and they subsequently make a decision that he was not eligible, then that has a significant impact on the election itself, because some people will have gone to the polls and voted for the MK party on the basis that Mr. Zuma was indeed a candidate. So this is this is the gravity of the issue, that it needs to be clarified ahead of the 29th, so that those of us going to the polls, and I hope that all registered South Africans will indeed do so, that we go there knowing exactly who the candidates are, who the political parties are, so we can cast our votes appropriately.
Lawson Naidoo, thank you, Executive Secretary of Casac. Really appreciate the time.